IVM.
There is no parallel to this achievement in any previous trade negotiations, all of which have been on a more limited scale. The completion of such a large number of simultaneous negotiations of such broad scope in a little over 6 months in itself is a remarkable feat. Since April 1947, when negotiations were open, nearly 1,000 scheduled meetings between the representatives of countries concerned have taken place in Geneva. In addition, there were continuous discussions of a less formal character between the delegations concerned. During the time when both tariff negotiations and charter discussions were proceeding, the delegations and their staff numbered approximately 760 persons. Welcome to States of Anarchy, a podcast on global affairs and foreign policy. I'm your host, Hamsani Hariharan. What you just heard was a press release from the United Nations in 1947, commemorating the signing of the General Agreement of Trade and Tariffs, or GATT. The GATT still exists, but it's been institutionalized in the World Trade Organization. Now, you may have heard a lot about the fall of the global liberal order because of the rise of populism and protectionism, and one interesting way that this is manifested was last year in the WTO. The WTO is an organization that gets a lot of hate from everybody. Developing countries claim that it's discriminatory towards them, developed countries feel like they're doing too much, but for nearly 25 years, the World Trade Organization has played a crucial role in mediating international trade disputes. The WTO's dispute settlement system has largely prevented damaging cycles of tariffs and retaliation outside internationally agreed upon rules and arbitration. Over the last couple of years, the United States has been signaling its displeasure at the WTO's appellate body, saying that it's been stretching beyond its limit. And all of this came to a close in December 2019, a month ago, when the US blocked the appointment of one of the judges of the appellate body. What does the tenure of judges mean for the WTO, I hear you thinking? It's like this. The minimum number of judges required for the appellate body to review a judgment is 3 people. So now, if a country is unhappy with any resolution of the WTO, they can appeal it, but it won't really go anywhere because there's no quorum for an appeal to take place. So the long and short of it is that the dispute mechanism system of the WTO can't function anymore. So what happens now if 2 countries have a trade dispute and they can't go to the WTO? That's what we are going to be looking into on today's episode of States of Anarchy. How did the WTO's success story turn sour? What are implications of the crisis within the WTO for global governance and international institutions? Is reform still possible? My guest for today has a unique perspective on all things IR. Vineet Hegde is a doctoral researcher and PhD candidate in law at the Leuven Center for Global Governance Studies and at the Institute of International Law, KU Leuven. His research focus is on international trade law and sustainable development, and he's also a researcher on the Connectivity Project, which looks at generating novel insights into how the current global crisis can be best resolved through international cooperation. Vineet also has a master's in international business and economic laws from Georgetown University. He's previously worked with the Commerce Wing at the Embassy of India in Washington, D.C., advising the government of India on international trade law and policy matters. We'll get into the conversation with Vineet after a short break.
Hey everybody, welcome to another awesome week on the IVM Podcast Network. If you are not following us on social media, please do. We're IVM Podcast on Twitter, Facebook, and Instagram. I'd like to thank our sponsors for the week, Storytel and Intel. Sponsors make this stuff possible. Please shout out to them. Let them know that you appreciate them paying us money. Also wanted to remind you all that we have an audience survey going. The audience survey is only going to be up for another couple of weeks, and I'm frankly disappointed. Even though 3 times the number of you people are listening to us as the last audio survey, only half of you have filled it out. So yeah, come on, please get to it. ivmpodcast.com/survey. We want your opinion to matter when we decide what we're going to do in the future, and I'm sure you want yours to matter too. So please do fill out the survey. A quick note, one of our favorite shows, States of Anarchy, hosted by the awesome Hamsani Hariharan. This show is going to move to a fortnightly schedule starting 21st January 2020. Keep listening to it. It's a great show on global affairs, foreign policy, and more. On Cyrus Says this week, Cyrus talks to YouTuber, actor, and comedian Sahil Kattar. Sahil talks about the discoverability of artists through YouTube, playing Syed Kirmani in the upcoming film 83, and watching Cyrus on TV while growing up. On Golgappa, host Tripti is joined by Girija Godbole. She speaks about how acting and theatre shaped her as a person. On Storytellers and Storytellers, Vineet is joined by Chitra Subramaniam from Cross Films and by Rahul Sarangi from TVF to talk about the export quality of entertainment. On the Empowering series, Zarina is in conversation with the host of Top Retail's Madhuri Advani. They talk about storytelling and ongoing issues in our country from CAA, NRC, and protests. On Agla Station Adulthood, Ayushi and Ritasha are joined by Andre Borges, a content creator, to unpack NRC, CAA, and how it's going to affect our country. On the Geek Fruit podcast, Tejas, Dinkar, and Jishnu talk about the best things according to them in pop culture from the 2010s. On the Habit Coach, Ashton talks about the fear of failure and how it's fine to fail. On Top Retails, Madhuri talks about the characters and gullies in her hometown Baroda in Gujarat as she tells us a story about his past and his present. On Ganatantra, hosts Saryu and Alok speak to Jean Thomas Martelli, who is writing a book on the Jawaharlal Nehru University and how a university becomes a hub of political activity. On Football Shitball, hosts Gaurav, Karthik, and Sivran celebrate the New Year episode and talk about the last week in football. And with that, let's get you back to your show.
Hi, Vineet. Welcome to States of Anarchy. Thank you so much for joining me on this.
Thank you very much for having me. Thank you all for the audience as well to listen to this episode on GATT, WTO, international trade, etc.
Yeah, let's dive straight in. How did the WTO come into existence? How is it different from GATT? What were its objectives? How did all of this start?
Right, so it's a long-winded history. So in 1947, 23 countries came together and agreed upon something called the General Agreement on Tariff and Trade. Now, out of these 23 countries, 10 were developing countries, etc. But this was the aftermath of the World War II. And also the problems that were persistent in the 1930 U.S. policies of Smoot-Hawley Tariff Act, right? So the idea of General Agreement on Tariff and Trade was mostly to reduce tariffs globally for all the members, signatories, not members. We'll come to that part later. But all the signatories to the General Agreement were committed to reducing tariffs. And one interesting part of history is that the initial draft of the GATT that was submitted was based on the 1942 US-Mexico agreement. So I think that sort of has a historical basis as well. Now, history-wise, if you look at it, there was much stagnation for like a long time in the sense that the idea of GATT was just to reduce tariffs, right? Until the 1948 to 1961, until the Dillon rounds is what I would call it. So there were rounds of negotiations during the GATT as well. So one is called the Dillon rounds between 48 and 61, which were also committed to reducing tariffs. Now, post 1961, from 1964 to 1967, called the Kennedy rounds, which also included something on anti-dumping. Now, for listeners, anti-dumping is where the regulations which control where if you're selling products in an export market at less than the cost that you're selling it at home market, now that constitutes dumping, and countries wanted to curb these issues, right? But then in the Kennedy rounds, only this was included. But I think the negotiations sort of intensified from 1973, where the Tokyo rounds that happened took care of a lot of issues that were put together. Right? One was, say, the subsidies code, or they were called the framework agreements because not every GATT signatory was a party to this or wanted to take up commitments on this. So these were called codes, like informal codes, because very small number of countries accepted this. So from 1973 until 1979, Tokyo rounds happened, but then again, there wasn't much success in this because of many countries not accepting this situation or like the agreements that were proposed. So if you look at the evolution and say the rounds of negotiation that happened during GATT, GATT was known as just an international treaty. Right? So it's mostly signatories to that agreement that are committed to reducing tariffs and sort of liberalizing trade. I think that was the agenda of GATT. But then the negotiations sort of intensified during the late 80s and early 90s. There were also because a lot of trade related measures that were not tariff oriented, but so they're called non tariff barriers. So any barrier to international trade that isn't a tariff measure is a non tariff barrier. And then these barriers increased during 70s and early 80s due to economic recessions, etc.
Can you give me an example of a non-tariff barrier?
A subsidy would be a non tariff barrier. Um,
Okay.
where there is a restriction of export because of government grants being provided to domestic producers, there is a change in the market orientation in the competitiveness. Right? And I think one of the most important aspects of international trade comes down to two words: comparative advantage. If there is a distortion in that comparative advantage, then there's a problem because producers from other countries face an issue because of that. So I think that's one of the examples I would call it. But then non-tariff barriers have gotten extremely complicated. Countries try and resolve it through different means now. So during the 70s and 80s as well, I think some of the forms of protection were based on subsidies for agricultural trade due to certain economic recession issues that happened. Now, because of all of that, there was intensified negotiations that started in late 1980s called the Uruguay rounds, which was the founding negotiating rounds for the WTO. Now, it was concluded in 1994 with a bunch of agreements which related to services, relating to sanitary measures, technical barriers, intellectual property, etc., and also the institutionalization of international trade through the World Trade Organization. So the World Trade Organization then came into being at the end or the conclusion of the Uruguay rounds.
So the WTO is different from GATT, right? So one is that it's institutionalized, whereas GATT is just a treaty. But were its objectives different? Were its objectives also sort of to focus on the liberalization of trade, or did it set out to do something that was allied but different?
So the WTO agreement had a broader aspect in the sense that it wanted to look at the standards of living. It looked at the economic development along with liberalization of trade, which is why you include the agreements on, say, there's an agreement called the Sanitary and Phytosanitary Measures Agreement, right? So, which means that a country can take a measure to protect public health, animal life, or etc., that might be a violation of trade rules, but this is for the to protect the health of the public. Right? So I think because of all of this, WTO's scope has broadened much from international trade to things that it touches upon, say in health, environment, etc.
Fair enough. And I think one of the things that the WTO also set out to do was to sort of figure out how to adjudicate on disputes, right? And I think this was considered a success story for many people. So what do you think it got right? And on the other hand, what did you think it didn't do well?
Right. So the dispute settlement mechanism of the WTO, at least, a lot of people call it the crown jewel of the WTO, which means that it's celebrated across member states to keep, it's an internal check and balance mechanism, which I don't think any international institution has enforced to such a robust mechanism. But before getting into the dispute settlement mechanism in the WTO, I think we need to go a little backwards in history to look at how the legalization in the WTO system, right? So around 1981 to 93, there was a ministerial declaration in 92 which led to the establishment of something called the Office of Legal Affairs. which then now in the WTO is called the Legal Affairs Division. I think it's this one of the most important turning points because although the dispute settlement existed during the GATT era initially as well, there were a bunch of failed, dispute settlement reports that came out until 81. I think it was 1976 to 81, which sort of gave the need to establish a legal affairs division in the GATT system. I think one of the most important panel reports that came out was Spain soybean oil case, which sort of had a very the ruling was had very little legal grounds to it, which then established the legal affairs division, which then only made the GATT system more legalized. And during like the late 80s, before the WTO was set up as well, the architect of the WTO system, Professor John Jackson, who is not with us anymore, he circulated a monograph that was, I think, published by the Chatham House in London, which is called The Restructuring of GATT System, which then sort of highlighted the fallacies in the GATT dispute settlement mechanism. And I think one of the most important aspects of the GATT system was the fact that if the panels that disputed or ruled between the disputing parties in a certain way, members could block the adoption of that panel report, and that panel report could never come into effect. Right. So I think, and it's much easier for a country to block the panel report if you're a losing party, and if you don't accept what the panel has said, you're going to block it. Which is all those things were highlighted in his monograph. And when the WTO system came into being, when the dispute settlement understanding, which is also like it's a procedural agreement for all the WTO substantive agreements, established something called the appellate body, which I think is an aspect that we must focus on at this point in the WTO institutional framework because it has gone beyond the point of crisis. Appellate body, which was established from 95, functioned until the 10th of December of 2019, which was a couple of days ago. And because of, one of the reasons why it stopped existing was also because of the success that it had, right? Appellate body functions as an appeal mechanism to panel reports. So it's the second instance. So the first instance of dispute settlement in the WTO system is the panel, which is also similar to the GATT system. So once the panel that is established rules on the dispute, and if a party intends to look at the questions of law, it appeals to the appellate body through the mechanism. And I think this is a very unique aspect of the WTO system, which many international or international organizations do not have. So for the success of the dispute settlement, I think it's very important to focus on the success of appellate body. Appellate body reports are almost always adopted. And I think there was one issue where where members sort of blocked the consensus on an issue that appellate body ruled, but it was not on the ruling of the law itself, but it was more on the acceptance of certain briefs, amicus briefs. So the mandate of appellate body is to preserve the rights and obligations of the members, right? And it's mandated also to clarify the existing provisions. So appellate body has succeeded in many ways to do that. And countries look at appellate body as an internal check and balance mechanism which enforces the WTO provisions and rights and obligations. And the success is the fact that almost always it's adopted. I think that says the success of it all. Almost all the panel, like appellate body reports were adopted at least. I think that's something that cannot be ignored for that matter.
So typically, if say India and another country have signed an agreement or are trading, then and if an issue sort of crops up, if someone accuses India of dumping or the other way around, then is it that both members would take their dispute to the appellate body and the appellate body would make a judgment which is more or less binding? Is that how it worked?
Yes, so the idea is that the way it goes about is that if a country has an issue with a domestic trade policy or international trade policy of a specific country, it takes to the dispute settlement mechanism, and it starts with a panel report or like a panel proceeding. Before that aspect itself, that's when the dispute resolution starts. But before that, there is a consultation procedure where countries consult with each other to see if they want to take this to dispute or not. Once they do that, it goes to the panel. The panel is established after that, and then if the countries are not satisfied with what the panel has to say, then they can appeal. Like it's more like a high court or a Supreme Court mechanism that is established in India.
Okay. And you said that one of the issues was also its successes in the sense of it did its job too well.
Yes, I think that's one of the most important aspects as well. I think I do mention it in the article that I wrote, where I say that the death of the appellate body was because of its success. It has functioned so well in maintaining rights and obligations, which sort of gave rise to the problem. Now, countries started claiming it, especially the US, started claiming that the WTO appellate body has gone beyond its mandate and sort of delves into the lawmaking aspect. And the mandate on the appellate body and the dispute settlement mechanism as well is the fact that it cannot change or impose existing rights and obligations or like impose new obligations on members, WTO members. The mandate of the dispute settlement mechanism is to preserve rights, not make them, and clarify the existing provisions. So it has gone beyond, and countries claim that it has gone beyond its mandate of preserving rights and obligations and clarifying provisions to more into lawmaking aspects. Now, I mean, the complaints of the US is not new because this started much long ago, like in 1997, 2 years after the the appellate body was established. Costa Rica, in one of the disputes, I think it's the U.S. wool shirts and blouse, stated that appellate body has diverged from its past practice and it has gone beyond to modify the balance of rights and obligations of the parties. The US as well, in one of the disputes, I think it was 98, it's called the Tax on Foreign Sales Corporation. The short title is USFSC, where US then stated as well that the appellate body appears to have unjustifiably expanded the scope of the action that it should take, right? So the concerns that the appellate body exercised its authority beyond its mandate is not new. It started since 97 in certain disputes when the countries felt that the appellate body shouldn't be ruling on certain aspects and it's going beyond its mandate. One of the most important reasons why this exists is because the WTO agreement that came into being, the umbrella agreement, states that for the interpretation of the treaties of the WTO agreement, it's the members who have the authority to do so. The members have the authority for interpreting these agreements through the ministerial conferences that happens at the level of, say, the Minister of Commerce and Industry and the Minister of Finance, etc., on that level delegation, or the General Council, which means that the permanent mission of India or other countries to the WTO, and this happens within the WTO. So the members per se have the authority to change the or make the interpretation and it is not vested on the dispute settlement mechanism through panels or appellate body. So I think that was one of the main issues that countries had, and the US took it to another level to block the appointment of the appellate body members. So because there was no appointments to the appellate body, the appellate body then went defunct because of the concerns that US raised.
Okay, so can we talk a little bit about like this crisis of the WTO that it's facing a little bit now, right? So it's good to know that the concerns that the US has are not new, because if you saw newspaper reports, you would think that this was sort of a Donald Trump conspiracy against international bodies. But so what exactly happened? Is it that the WTO doesn't function? A lot of newspapers and other media organizations have said that this is sort of the death of the WTO. So can you sort of fill us in on why the appellate body is no longer functioning?
Also, to clarify certain aspects, when you say that there's a death of the WTO, I think that's a long-winded prediction which might not be true, because WTO also has a negotiating arm. Through they have multiple divisions, and there are a lot of committees set up. Say the Committee on Trade and Development, Committee on Trade and Environment. There's a negotiating group. There's a rules division, etc. So there are different divisions compared along with the legal affairs division and the appellate body secretariat. So it's very important to know that there is a negotiating forum at the WTO as well, which is still functioning at a high level, and the US, who has blocked appellate body appointments, is also actively engaging in making proposals, reforming the system, etc., on a lot of issues in the negotiating forum. So if you say that the WTO system is about to die, I personally think that that's not a valid claim to make. I think we have to look at the effects of the death of the appellate body on other aspects of the WTO. But saying that the death of WTO itself because of this issue, I think that's still a bit of a far-fetched statement.
I completely agree. I was just sort of quoting from a lot of these newspapers that were reporting it as such. But just sort of to clarify, what happened was that the tenure of the judges lapses every couple of years, right? And what the US has effectively done is to block the appointment of new judges, and therefore it means that the body can't function. Am I summing that up right?
Yes, you are. And the funny anecdote to that is the fact that you call them judges. And that's exactly what the US has a problem with. They were not supposed to be judges, which is why the terminology for them is appellate body members. So what happened was the fact that there were three appellate body members functioning, and when the time for appointing new members or the reappointment of the existing members came, the US kept blocking these appointments, which meant that, and the minimum number of members to function is three. So if it goes below three, then the appellate body practically goes defunct, right? So the appeals that are taken up cannot be adjudicated upon because there are no three members. So I think that's one thing that needs to be kept in mind as well. So the blockage of appointment and reappointment of the appellate body members was one of the major issues. And the US let it lapse. And there were three members until the 10th of December. And now two members have retired. And I think there's only one at this point. So which then makes it practically defunct.
Okay, so which means that there may not be further appointments of members, or if someone wants to appeal a case, then the case is essentially just stuck in limbo.
Right, exactly. So what happens is that, so if there is a dispute, you start with consultations, and then a panel is established, etc., and then a panel makes a ruling. Now, if the member appeals that panel report, now what happens is that because the appellate body doesn't exist or is practically defunct at this point, which means that the dispute settlement body, which adopts the panel reports or the appellate body reports, cannot adopt the panel reports because it's now appealed. right? So then what academics now call it is that the panel reports have gone into void, which only means that the decision of the panel cannot be adopted. And that creates sort of an issue because the outcome of the panel report is never implemented.
Fair enough. So, what does this mean for the WTO? What are the implications of this for international institutions, for global governance? What do you think?
So the problem, I think, some of the problems that can arise is the fact that, and a lot of people call it now, they call it vigilance justice, right? So what happens is that if a panel report comes out and it's appealed, the panel report in appeal then goes into void, then members can start taking actions on their own. So, giving an example, say a country A goes against country B to the dispute settlement mechanism. A panel report came out which states that country A is authorized to retaliate against country B for, say, $1 million. Right now, if this is appealed, that retaliation of $1 million cannot be adopted. But what it can do is it can start taking unilateral measures where it can start then imposing the retaliatory measures, which can exceed what the panel has proposed as well. And this sort of creates an over enforcement of trade rules rather than under enforcement of trade rules. Now, more and more countries will start retaliating, or hopefully not, but there is a possibility that they start retaliating more and more, which then just becomes like a spaghetti bowl of increased trade measures, which wasn't the idea of the WTO or the GATT itself, right? So it goes against the principles of WTO and GATT of economic liberalization if countries start taking unilateral measures.
Fair enough. And what do you think this means? I don't know. There's a lot of talk about sort of, the international liberal order is crumbling and there's rising protectionism and all of that. Do you think this is a side effect of that? Do you think this is one of the reasons that this has happened?
Uh, One of the reasons, yes, I would say so, because um, the US narrative for now has been that, at least let's go with the US narrative for now, because it's a very important player at the WTO as well. Um, for now, has been they've lost at the WTO per se, and there is so much losing because of international trade, etc., which then there's a slippery slope effect, and then it goes on with the aspect of taking, measures in its own hands, etc., which then have an implications on other aspects of geopolitics. So the belief in multilateralism is crumbling, and countries have started taking unilateral measures on their own, which sort of makes it very difficult to protect the liberal order because the establishment of the liberal order was also, at least in the international trading system, was through the multilateral setup because not all problems can be resolved bilaterally, like how the US claims it now. It has renegotiated a lot of trade agreements. It is in negotiations for a lot of trade deals with countries, etc. But certain measures have international spillover effect, which only require multilateral rules and multilateral solutions, which means that if that doesn't happen, then the liberal multilateral order will crumble. And this will have effects in for other aspects as well, not just international trade. So it's a bigger geopolitical issue.
So something strikes me when we're talking about the US as a stakeholder, right? Is
Right.
it that all countries have equal stake in the WTO? Is it that any country can block the nomination of members, or is it just a certain set of countries?
So each country gets a membership vote, right? So every country is equally within the WTO setup. The US is equivalent to China or India or any other WTO member. But the reason why US becomes a very important player here is because it played a very important role during the GATT setup, during the WTO negotiating round, and even now because US contributes a lot to the WTO via its budget, right? And people know that if members go around the US to appoint WTO appellate body members, which only means that you are going against one of the most important global international trade player, which you can have implications later on by say sanctions or retaliations, or US can even pull out of the WTO, right? Because of that, and US contributes a lot to the budget of the WTO, which only makes it a very important player. So it cannot be ignored. And because of US's actions, other countries are taking actions now in a unilateral measure, which, like I said, it's a spillover effect. And then now those countries have also become important in the system too, and cannot be ignored.
Fair enough. So, is there a way out? Is there a way that you can still sort of reform the WTO system? How should we look at the way to go forward?
Again, before going into the way forward, I think like I want to roll back a bit and say what exactly were the issues that the US raised on appellate bodies so that we know what to reform and how to reform, right? Um, so the US never assumed the appellate body to function as a court, and many aspects of the appellate body is that people, like members or like people pursue it to function as an appellate court, which US says it has never agreed to do so. If you look at the like early 90s Senate hearing of say experts on WTO at the US Congress, the Senate and the House, etc., they say that the appellate body was not supposed to, or the appellate body would not intervene in the sovereignty of the US. And the idea that recognizing, or like the idea of judgments don't exist in international law, and the sovereignty of the US is not threatened because any interpretation of the WTO agreement can be modified by the members itself. That was the idea. But then the appellate body went on a lot of things. It condemned the certain methodology calculations in dumping related investigations of the US, which US was not very happy about. It also looked into China's state-owned enterprises, right? So I think that's a very important aspect that is still pertinent and is still going on, is the fact that how do you determine what body is a government authority and what is not? And because if so, the determination of this is important to see who gives a subsidy and whether it's a subsidy or not. So a subsidy is within the definition of the WTO agreement on subsidies only if it's granted by a government or a public body. And the appellate body sort of went against the idea or the interpretation of what the US had. And you know how it is in the conflict between superpower and a rising power, etc. So the US tried to put China down through that, but the appellate body sort of held parts of China's interpretation, etc. So even this is so the appellate body also issue is also like involved quite well with what US has against China as well. So all of this are quite muddled. So I think dispute settlement, just looking at the fact that appellate body has exceeded its mandate is not the only way to look about it, but also we need to look at why it's come to this. And in an interview with the General Counsel of the U.S. Trade Representative's Office, his name is Steve Vaughan, he said that when we look at the dispute settlement understanding, which is the agreement that is the procedural law for to resolve the disputes of the substantive WTO agreements, it says that there is some misunderstanding between what the US thinks and what the other countries think. Now, the European Union looks at appellate body as something like the ECJ, European Court of Justice, But the US never, they say that we've never agreed to give up so much of our sovereignty to something called a court. We wanted the appellate body just to clarify what the existing provisions were and if there was a question of law to be interpreted. So the way the US looks at the writing of what the appellate body's mandate was and what the rest of the world looks at it, it's sort of different. And I think that's a very important gap that needs to be bridged before we move into any further reforms, right? But when you do, there are a couple of reforms that countries have suggested because it's a very important aspect of the institution and the crisis will definitely hit other countries as well. Um, some countries have looked into something called the interim arbitration agreement, which means that um, after the panel report is out, and if you're not happy with the panel report until the WTO appellate body is restored, you sort of go into arbitration of that dispute. But there are a lot of issues. Before moving forward, I think that's very important. So the misunderstanding needs to be bridged to see what exactly was perceived of the appellate body. I think that's a very important aspect to look at.
When we're talking about issues that different members bring up, right? India, from its own past, has also brought up issues of subsidies that US farmers get from the US government. So when it comes to how countries look at the appellate tribunal, isn't there always going to sort of be a push and pull of negotiations that countries are going to sort of go through just so that they can get the best possible outcomes for themselves?
Right. So that's the idea of dispute settlement as well, right? So for you to put your best case forward to see if you see whichever way you can win the argument and make sure that you get the best benefit for your producer based on the interpretation of the WTO agreement. So what the US says now is that if there are issues of subsidies that we need to talk about, let's look at it in the negotiating forum so that there is more politicization of that issue rather than looking at in a legal way. And I think that's where we're heading towards. Back to the political aspect rather than more legalization of it. So I think there is definitely going to be a push and pull about these issues, and I think countries need to keep in mind that the amount of contribution they make to the growth of international trade as well.
Fair enough. So when we talk about India, what do you think this means for India, the suspension of the appellate body? Because India has also sort of had its own problematic history with the WTO, right? When you consider all the rounds of negotiations that have been held.
I mean, as simple as this, like India has the issues that most other countries as well have, who are protecting the dispute settlement mechanism through multilateralization and the appellate body, right? So it's quite a common concern that India shares with most other countries as well. Now, the most interesting aspect for India and why WTO is extremely important for India at least is that I think the share of trade in GDP is sort of most like it's the highest as compared to other countries. Now, if you look at in the US's international trade ratio in its GDP, it was sort of 27% in 2017, and China's portion of international trade in its GDP was 38% in 2018. But India hit 53% in 2013 itself. So like India has a very important stake in protecting the WTO itself because international trade has brought about so much of revenue in its GDP. So I think that's a very important aspect to be remembered for India to go forward, take action, or like take leadership in reforming the system itself.
All right. This is my last question for you, Vineet. What books or resources would you recommend for people who want to read more about the WTO?
If I have to be honest about this, the WTO website does the best job in accumulating everything that they have. I think readers should start with the WTO website itself. It's quite informative on most or like almost everything that the WTO does. Right? So I think that's a very important step to begin with. Another book that a friend of mine gifted me when I was starting my masters was this. It's a very short introduction by Professor Amrita Narelkar. It's called the World Trade Organization. It's published by the Oxford University Press. I think it's good to start with. After that short introduction by Narelkar, I think what helped me in understanding this magical world of WTO was at least this book by Professor John Jackson, William Davey, and Alan Sykes. It's called The Legal Problems of International Economic Relations. It has gone through many revisions, etc., but I think it's a very important book that can, help students or professors or anyone who wants to understand WTO law in absolute depth.
Okay, awesome. Thank you, Vineet. Thank you so much for joining us today.
Thank you very much. Thank you for the audience as well.
That's it for this episode of States of Anarchy. Thank you for staying with us. As usual, I've attached all of Vineet's recommended readings in the episode description if you want to read more. If you want to delve deeper into some of the topics that we discuss on States of Anarchy, whether it's public policy or foreign policy, I suggest that you check out some of the policy courses at the Takshashila Institution. They're of varying lengths, so you can choose depending on your interest, and you can attend the classes from home. So do check them out. If you have any comments or questions, you can reach out to me at HamsiniH on Twitter and at States of Anarchy on Instagram. You can listen to States of Anarchy. Not only on the IVM Podcast app and website, but on iTunes, Spotify, Ghana, or wherever you get your podcast from. We'll be back soon.
नमस्ते, मैं हूं सौरभ चंद्रा
और मैं प्रणय कुटस्थाने।
जब महफिल खत्म होते होते दरवाजे के बाहर पुलिया के ऊपर हम दुनिया भर की जटिल समस्याओं को सॉल्व करने में लग जाते हैं तो हो जाती है पुलियाबाजी।
अब आजकल के अपार्टमेंट वालों ने तो कभी पुलिया देखी नहीं होगी, पर आप फीलिंग तो समझ ही सकते हैं।
तो आइए शामिल हो जाइए हमारी पुलियाबाजी में, जहां प्रणय और मैं एक से एक इंटरेस्टिंग टॉपिक्स की तह तक जाएंगे।
आर्टिफिशियल इंटेलिजेंस, बिटकॉइन, पाकिस्तान, मेडिकल एजुकेशन, करेंसी क्राइसिस, कभी हम दोनों के साथ और अक्सर स्पेशल एक्सपर्ट गेस्ट की कंपनी में।
सुनिए हमें IVM की वेबसाइट, ऐप या अपने फेवरेट पॉडकास्टिंग प्लेटफॉर्म पर हर दूसरे हफ्ते।
Hi, I'm Sarayu Natarajan.
And I'm Alok Prasanna Kumar.
And we are the hosts of the Ganatantra podcast.
On this podcast, we speak to academics, social scientists, journalists, and activists to find out what's actually going on in Indian politics.
On this podcast, we stay away from personality politics, intrigue, and gossip, and instead focus on the data, research, and analysis that drives all this.
So tune in to the Ganatantra podcast, where new episodes are out every Wednesday on the IVM Podcast app, website, or wherever you listen to your podcasts.